In a pivotal session of South Africa's Madlanga Commission of Inquiry, witness Suliman Karim's legal team suffered a devastating blow when their unprecedented bid to have the in-camera application itself heard behind closed doors was systematically dismantled by the commissioners and ultimately refused by Chairperson Madlanga. Commissioner Kumalo delivered a sharp rebuke, telling the advocate there was no need for all the drama and urging him to simply abandon the prayer. When the advocate refused, insisting he would rather the commission rule against him than voluntarily withdraw, the commissioners obliged. Evidence leader Miss Hassim then delivered a pointed rebuttal, confirming there had never been a single breach of confidentiality by the commission and that the directive clearly stated this was to be an open session all along. The advocate made a final dramatic plea, reminding the commission that 2 witnesses had been killed after testifying, but Madlanga swiftly corrected the record, revealing that the person who committed suicide was never actually a witness before the commission. Commissioner Kumalo then exposed fatal flaws in the notice of motion, showing that prayers 3 and 4 would effectively block the commission's own investigators, security head, and researchers from doing their jobs. Moments later, Chairperson Madlanga delivered the ruling. The application was refused and the merits would be heard in full open session, with written reasons to follow on Monday.
Thank you very much, Commissioner Kumalo, for the indulgence.
I don't want us to debate the point I made, because I think the preliminary point has become, I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Did I get the impression that but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassim gets an opportunity.
That's where I want to go to. That's where I want to go.
Although are you accepting your abandoning too, so that we don't need to debate?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay. All right.
Thank you, Chair.
Ms. Hassim?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits because, as Commissioner Baloyi says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or 2 of my learned friend's address, we strayed right into the merits. And so part of what's been debated in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say 1 or 2 other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission.
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premhid will probably say neither he is instructing attorney nor Mr. Karim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the commission before they appear before the commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the commission and the status of rulings that are given by the commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the chair's reconsideration of the ruling, which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination. It wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Ms. Premhid, one last. Yes. Any response, Mr. Premhid?
Yes, three very brief ones, if I may. In respect of the first point made by my learned friend about her understanding of the directive, with all due respect, it's not her understanding that matters. It's what the commission makes of the application and the request for the ruling beforehand. And that's why the ruling was made beforehand. The request for the ruling was made beforehand, so my client wouldn't find himself in the exact position he finds himself in at the moment. On the second point, my learned friend, in fact, actually makes the case for us, because her exact words were, it's the determination of this application that would thereafter determine the disclosure of the main statement. And that's exactly why, not only in the correspondence and in the notice of motion, but in the founding affidavit, before that statement was due, the direct application was made at paginated page 12 of the pleadings bundle, paragraph 27, humbly the request that the commission determine this matter as one of urgency. This is because my witness statement is due on Friday, the 27th of February, 2026. If a determination is not made about my hearing evidence in camera, and with that regarding the witness statement by this date, then my witness statement will be made available to the general public, defeating the purpose of this application. If that was wrong, they filed the answering affidavit on the 24th of February. They could have made the undertaking or given the clarity on the 24th of February that the statement wouldn't be disclosed.
But why would he have thought, and I think that's a point that Ms. Hassim was making, that his statement would be made public before he testified? On what basis does he have that concern to a point where he doesn't abide or comply with a clear directive? But
that's because as the chairperson foreshadowed, is that my client doesn't have knowledge of the inner workings of the commission.
It's not about the inner workings. It's about what he has done, and I have to deal with this by way of an example. He has made a claim. He's making a claim for confidentiality and for in-camera, based on the threats he has received, but matters that he says are reported in the public domain. He's made references and he's annexed stuff that is in the media. So he's relied on matter that is in the public domain. I'm asking a question like that there is nothing, he knows nothing about the processes of the commission, as you rightly say. He doesn't know our internal workings. But again, he has nothing from the public space that is a basis for that concern about his statement being made available to the public. He makes it up. He makes it up, and on the basis of that fear that he's making up, he then says, I'm not going to file my statement until you give a ruling because it might go into the public, when there's absolutely no basis whatsoever, no factual basis for him to raise that kind of concern, and therefore not to abide a ruling that says you must file by a certain date. So it's not an answer to say, I guess what I'm doing is I'm saying, how reasonable is this fear about my statement will be disclosed to the public when there's absolutely no factual basis for it?
I accept that, and you've already heard me in my opening remarks that, to the extent that explanation is needed in the affidavit directly, it's not there, and I'm not going to push at that. Instead, what I will say, at the risk of repetition, is that that's the very reason why the ruling was asked for by the 25th, so that he wouldn't be in the position of potential non-compliance, because that clarity, and on the basis that Commissioner Baloy has accepted, he wouldn't know the internal working processes, would be given to him. And so when I was reading from the founding affidavit and I mentioned the answering affidavit that came on the 24th, that was the day before the ruling was originally sought. And if the commission in its answering affidavit simply said, we'll give you the confidentiality pending the determination of the in-camera, then that would have cleared the path to file on the 27th. And so those are the facts about what came before the commission. And we can't, with all due respect in assessing reasonableness, determine the unreasonableness or the alleged unreasonableness of my client's conduct without those important factual features. Can I just say one more thing, Commissioner Baloy, and then I must make my third concluding remark in response to my learned friend, Miss Hassim. On my client doesn't rely on threats in the public domain. My client relies, and that's what I understood Commissioner Baloy to have said about things in the public domain. If I misunderstood that.
Yeah, no, you misunderstood me.
Okay.
Yes, I wasn't saying he relies on threats in the public, made to him in the public domain. I was saying there is nothing in the public domain that finds
the breach.
Founds.
Yes,
yeah, absolutely.
Yes.
That's
Now,
the point.
then we're ad idem. Then I don't have to say anything further. I understand what you were saying, Commissioner Baloy. Thank you. And then lastly, in respect of the issue of the threats, I think it's also just important to say it out loud and on the record that 2 witnesses that have come before this commission have been killed. One allegedly killed themselves by means of suicide, but did so after there was an attempt on their lives, and the other was apparently killed potentially or allegedly in relation to what they may not or may not have done here. And all I would say in conclusion, in reminding the commission of that, is that your job and mandate is about serious issues that go to the heart of the criminal justice system and potential abuse of political connections, criminal connections, and political power, which threatens a huge many deal of interests of people. And where witnesses are dying after coming to the commission and giving evidence, it's surely not unreasonable in those circumstances that my client uses whatever procedural remedies are available to him to try and get relief from this commission to protect him in some way to make sure he's not subject to the same kind of treatment which is evidenced in his founding affidavit. Thank you, Chair.
Mr. Permit, I don't want to leave it uncorrected that the person who committed suicide testified before this commission. That person was never a witness before this commission.
I apologize.
I don't want it to be left that way in the public.
I apologize.
Because factually,
I spoke then subject to being told the incorrect thing. I apologize then. And I withdraw that to the extent I need to.
That actually deals with part of my preliminary point.
Ms. Premier, you're going to go into the merits, and maybe just you'll deal with this in the merits. I don't want you to deal with it now. So I can either, in advance of you arguing it, just tell you what my concern is, and then you will deal with it when you argue, and then we can raise questions as you go along. If you look at prayer 3 and 4 of your notice of motion, read with your Schedule A. The effect of it is that the Commission's investigation team must not have access to these documents. The Commission's head of security must not hear this evidence, must not have access to these documents. Now, that is problematic because that is the work of the Commission. There is no way you can have a prayer. And our researchers, there's no way you can have a prayer that says the very evidence that's going to be led, your investigator must not hear or know about it. Because their job is to investigate everything that is presented and provide the Commission with facts. So the prayers are problematic. And I will just give you an example with prayer 3. We have, for example, a Mr. Brown Mokgotsi still coming to finish his evidence. If your client, either in his statement or in his evidence, says something that implicates Mr. Mokgotsi, or that Mr. Mokgotsi would like to respond to, Mr. Mokgotsi and his representatives must have access to that in the same way that your client had access to the evidence of Mr. Mokgotsi. And you would have said it's prejudicial to your client if they were not given the evidence and the statement. So it has to work both ways. If your client mentions any person and gives evidence against them, they would be entitled to that. So you cannot have a situation where all papers exchanged in relation to your client's evidence are not disclosed. It cannot just be this open-ended. And then you've had me on the Commission staff, especially, on matters of security, for example. The Commission's head of security, and I won't go into detail because those are sensitive matters.
And internal processes which we're not aware of, absolutely.
To assess what security arrangements
Sure.
have to be made, he needs to have access to all of this. So you cannot say he must not have access because how else does he do his job? Do you follow me?
Yeah, no, I do.
Yeah.
Chair,
I'm sorry. Commissioner Kumalo said that that's for when you address the merits and that think about it and deal with it when you address the merits. I think we've reached that. You were to?
That's why I was looking to you to give me direction whether it's now time to address the merits or not.
No. Let's adjourn for 5 or so minutes, give or take. We'll indicate when we are ready. So we are not strictly saying 5 minutes. It may be more. Let's adjourn.
Thank you.
My direction is to refuse that the main application, be heard in camera. That's my order. So it will be, the merits of that application will be heard here in open session. Reasons will be given on Monday.